Bonjour. This video discusses the topic of judicial review, asking a fundamental question. Can courts in a given jurisdiction rule on the constitutionality of legislation? Do judges have the power to discard or annul an unconstitutional provision? This is a complex question. Judicial review raises an issue of separation of powers. Judicial review may be seen as an infringement of the legislative power by the judiciary. Judicial review interferes with the will of the people as expressed through its representatives. As such, it questions the fundamental principles of a democracy. Indeed, the Constitution is the fundamental law of the land because it reflects the will of the people. Legislation is law because it reflects the will of the people. The people may accept permanently or temporarily to suspend or abandon a constitutional rule or protection. Think of legislation in times of terror attacks or pandemics, or whenever there is a national emergency. People are sometimes willing to sacrifice freedom and privacy for better protection. On the one hand, you may want the people to prevail and leave the courts out of it. On the other hand, you may want the rule of law to prevail and courts to review in order to make sure that fundamental rights are protected at all times. I hope you see the tension between these two fundamental ideas. Let us give them simple and easy names. On the one side, you have the demos, the Greek word to describe the people. Demos gave the word democracy, meaning the government of the people, by the people, and for the people. On the other hand, you have the rule of law, protecting minorities against harmful choices made by a sometimes oppressive or manipulative majority conducive of discriminations. We will play with these two sets of terms, the demos against the rule of law. These two forces can work together or pull in separate directions. Read Yascha Mounk, The People versus Democracy, 2018. Regarding judicial review, the fault line between the demos and the rule of law cuts across the civil law and common law divide. At all times, the US was a champion of the rule of law. Judicial review is the bedrock of the American Republic. It is part of its DNA. It is embedded in the US Constitution, though not visibly, just like DNA. You don't see DNA. As Chief Justice Marshall said in Marbury v. Madison, the government of the United States has been emphatically termed a government of laws and not of men, which means that the rule of law overrides the demos. The Constitution is above ordinary legislation, and it is the task of the judiciary to make sure Congress does not usurp the power to change the Constitution by legislating against it. The US view of judicial review has become viral or universal on the Western Hemisphere. Canada has it. Latin American countries have it. All on the Marbury versus Madison mode, though Latin American countries have the civil law. In the UK, things went differently. There is no written constitution, and Parliament is said to be sovereign, with the power to do and undo all rules, even if they have a constitutional nature. The Supreme Court of the UK does not have the power to strike down legislation that infringes constitutional rules or principles. When the British Parliament adopted the 1998 Human Rights Act to implement the European Convention on Human Rights, it accepted to limit its powers for the time being, as long as the UK decides to honor its commitment under the European Treaty. Now look, the two leading common law countries go different directions. The rule of law is a priority in the US, and the UK seems to go by the demos. This does not mean that the UK does not take care of the rule of law. It always did. In the middle of the 13th century, Henry of Bracton wrote in his treatise on the laws and customs of England, quote, "The king should be under no man, but under God and the law, for the law makes the king." See the nation's motto, Dieu est mon droit, meaning God and my law. It took a few centuries to become a reality. Parliament worked hard at curbing the royal power and eliminating its absolute character. England does not have a history of an abusive parliament. On the contrary, Parliament passed the Bill of Rights in 1688, making itself the champion of liberties. Though sovereign, the British Parliament has a history of acting with self-restraint. The court could safely abandon the doctrine of the equity of the statute, which allowed them to set aside unreasonable provisions. The only judicial review the UK has ever had in modern history comes from the continent, and not directly from English courts. UK legislation infringing the EU Treaty or legislation could be reviewed by the Luxembourg-based Court of Justice of the European Union. This is a very touchy subject, and it had its bearing over Brexit. Past the Brexit, the tension is on the human rights front, as the UK remains a party to the above-mentioned European Convention on Human Rights. UK legislation can be reviewed by the Strasbourg-based European Court of Human Rights, another outside international court. Not that the UK has anything against human rights, but they resent its definition to be ruled upon by a non-English court. Let us cross the English Channel and visit the European continent. Again, I will keep things simple, as this is an outline. Nations of continental Europe started a slow, at times brutal, move towards democracy in the wake of the French Revolution. The leading word was demos. The revolutionary idea is that what the will of the people as expressed in duly passed legislation cannot be illegal. The will of the people is the will of its majority. With a history of courts serving the interest of kings and aristocrats rather than championing people's rights, there was more trust in the representatives of the people than in judges. With the exception of Austria, no European country had judicial review of legislative action before World War II. However, in the wake of World War I, dictatorial regimes mushroomed in Europe, as they did in Russia. The people made wrong choices, bringing dictators like Hitler, Mussolini, Franco, and Stalin to power. Representatives of the people adopted repressive legislation. Re-establishing democracy after World War II had to go beyond the demos. The rule of law had to be part of the equation. This was done at a continental level with the adoption of the European Convention on Human Rights in 1951. In addition, a number of countries, but not all of them, adopted judicial review. What are these countries? The first two are Western Germany and Italy, the countries of Hitler and Mussolini. They did not adopt a Marbury v. Madison approach, opening a right of review to ordinary courts. Special courts were created at the top of the judiciary called Constitutional Court. These courts do not try cases, but they can rule on the constitutionality of statutes in a number of ways. To keep matters simple, there are two types of review. Type 1 is called abstract review. It only targets the new laws before they make it to the books. Some politicians can, right after the vote of legislation, challenge its constitutionality in the abstract before the act is passed into law, before it is ever applied. The idea is to kill the dangerous snake in the egg before it can do any harm. Type 2 is review in the context of a case. This one can target earlier laws. The constitutionality of the provision is discussed in the ordinary court, but the judge cannot pronounce on its constitutionality, however. The court can mitigate or eliminate the problem, choosing an interpretation that does not harm a constitutionally protected interest, but cannot strike down a provision on ground of unconstitutionality. Only the Constitutional Court can do this. For this to happen, parties have to appeal all the way up to the highest court. If convinced that there is a constitutional issue, the highest court will refer the case to the Constitutional Court. Only that court can annul the unconstitutional provision or order it to be interpreted in a constitutional manner. Note that it has the advantage of cleaning the books. Europeans do not keep unconstitutional provisions in their codes, as happens in the US. They are removed on the order of the Constitutional Court. Germany and Italy were the champions of judicial review on the European continent. They were the only two European countries to have it when I started law school, France then having a much weaker review, as discussed in another video. Other nations followed suit when freeing themselves from totalitarian regimes. There was a first waves in the 1970s with Spain after the death of General Franco, Portugal after the demise of General Salazar, Greece once rid of the colonels. And then, after the fall of the Berlin Wall in 1989, countries of Eastern Europe did the same. The German-Italian model dominates the continent. France did things differently, trusting the demos, as it did not recognize itself as a past authoritarian regime after World War II. General de Gaulle claimed a seat among the victors. I will discuss the French experience in the forthcoming video. And for the time being, say goodbye, merci, danke, grazie.